Be ready. Ready. Start. We are of the opinion that the view propounded by the High Courts of Bombay and Calcutta represents the correct state of the law. However, we may add that it shall be the endeavour of every court in which a Section 34 application is filed to stick to the time limit of 1 year from the date of service of notice to the opposite party by the applicant or by the court as the case may be. In case the court issues notice after the period mentioned in section 34(3) has elapsed, every court shall endeavour to dispose of section 34 application within a period of 1 year from the date of filing of the application. Similar to what has been provided in section 14 of the Commercial Courts, Commercial Division and Commercial Appellate Division of High Courts Act 2015. This will give effect to the object sought to be achieved by adding section 13(6) by the 2015 Amendment Act. We may also add that in cases covered by section 10 read with section 14 of the Commercial Courts, Commercial Division and Commercial Appellate Division of High Courts Act 2015, the Commercial Appellate Division shall endeavour to dispose of appeals filed before it within 6 months as stipulated. Appeals which are not so covered will also be disposed of as expeditiously as possible, preferably within 1 year from the date on which the appeal is filed. It will thus be seen that speedy resolution of arbitral disputes has been the reason for enacting the 1996 Act and continues to be the reason for aiding amendments to the said Act to strengthen the aforesaid object. Quite obviously, if issues are to be framed and oral evidence taken in a summary proceeding under section 34, this object will be defeated. It is also on the cards that if bill number 100 of 2018 is passed, then evidence at the stage of section 34 application will be dispensed with altogether. Given the current state of the law, we are of the view that the two early Delhi High Court judgments cited by us herein above correctly reflect the position in law as to furnishing proof under section 34(2)(a). So does the Calcutta High Court judgment. We may hasten to add that if the procedure followed by the Punjab and Haryana High Court judgment is to be adhered to, the time limit of 1 year would only be observed in most cases in the breach. We therefore overrule the said decision. We are constrained to observe that Fizza Developers was a step in the right direction, as its ultimate ratio is that issues need not be struck at the stage of hearing of section 34 application, which is a summary procedure. However, this judgment must now be read in the light of the amendment made in section 34(5) and 34(6). So read, we clarify the legal position by stating that an application for setting aside an arbitral award will not ordinarily require anything beyond the record that was before the arbitrator. However, if there are matters not contained in such record and are relevant to the determination of issues arising under section 34(2)(a), they may be brought to the notice of the court by way of affidavits filed by both parties. Cross-examination of persons swearing to the affidavits should not be allowed unless absolutely necessary, as the truth will emerge on a reading of the affidavits filed by both parties. We therefore set aside the judgment of the Delhi High Court and reinstate that of the learned Additional District Judge dated 22/9/2016. The appeal is accordingly allowed with no order as to cost. Stop.